In the session, I am going to share my screen so that hopefully, and I need to click a couple more times. All right, so I'm going to share my screen and hopefully that worked. It looks like it did. All right. Like Lisa said, my name is Tracie Dominique Boyd. I'm a lawyer. So with that comes a lot of baggage. Please don't make that be intimidating for you. I want you to ask questions. I want this to be an engaging conversation for all of us, because that's how we learn best, right? It's always better when you have context for what you're learning rather than just trying to retain concepts in the abstract. But because I'm a lawyer, the baggage that comes along with that is the attorney-client privilege. So each of you are individuals, you each have lives, you each have loved ones. When you ask me a question, I ask you, please make it in the hypothetical. Do not make it specific to you or to any specific individual that you know and love. There's a reason for that, because I can't give you legal advice in a public forum such as this. We're here with some of our brand new friends that we've never met before, but not only that, this session is being recorded and will be broadcast on the Senior Regional Collaborative's YouTube channel, and we don't know who's going to watch it. So we don't have the protection of that confidentiality bubble that the attorney-client privilege is supposed to give us. So if you do it, frame a question in a very personal type way, or if there are some very specific facts to your hypothetical, I might decline politely to answer it, or I might answer a different question to make it more generic, so that we're not trying to violate that confidentiality. The other thing is I cannot, under the rules of ethics that govern lawyers, I can't give third-party individuals specific legal advice that I know they're going to pass on to somebody else. Because it becomes a game of telephone, right? So if you intend to ask me a question and say, start it off with, my friend has this going on, I will also politely decline to answer it, and I'll make it a little more generic in my answer so it's more applicable to a broader range of folks. So without further ado, let's talk about end of life planning. Our learning goals for today, hopefully, are to understand how powers of attorney can help protect you from having to be the subject of a guardianship or a conservatorship or both proceeding through the probate court system. We want to all understand and be on the same page as to what a durable power of attorney is. I hope that you will all understand that a durable power of attorney for financial or business transactions requires very specific protectional language under the Michigan Uniform Power of Attorney Act, which is relatively new, just went into effect July 1st of 2024. And I want to make sure that we all understand what a durable power of attorney for healthcare or for medical care means and how that works. And finally, I want to talk about, if we have time, the difference between that durable power of attorney for healthcare and what lawyers call an advance directive, but what normal people usually refer to as a living will. So let's get started. The first thing we have to think of and inquire about is whether or not the person who is wanting to create and execute these documents has what's called the legal capacity for decision making. And all that means is that you're of sound mind, that you can safely, freely, and voluntarily make your own decisions as an adult human being without being unduly influenced in some way by another person, or by not fully understanding the decision you're being asked to make or that you're choosing to make. So that legal capacity for decision making is always the first inquiry that I, as a lawyer, need to do when I'm working with a client to make sure that I'm comfortable proceeding with doing any legal work on their behalf or at their request. So let's talk about the durable power of attorney. So the acronym is DPOA. And if you were with us last week, you heard one of the participants ask why I kept talking about the Police Association Union. So that's an acronym that a lot of different professionals use for different reasons. So if I slip up and start speaking in acronyms, DPOA stands for this, durable power of attorney, in this instance and in this setting. So, what's great about doing a durable power of attorney is that you, as the principal, you, as the person who is drafting and executing the document, you get to choose who your agent will be once you reach a phase in your life when you are no longer able to make your own decisions, when it's no longer safe for you to make your own decisions, or if you have been impaired either through a physical life challenge or a mental health challenge, or both, a combination of both. And so, this durable power of attorney, you are voluntarily giving up some or all of your decision-making power as an adult human being to another third party, another adult person or persons that you choose. That's important. So the reason that we want to consider this pre-planning piece and doing this type of a document now while you have the legal capacity for decision making is to protect you in the future from your caregiver or your loved one, or could be the same person, right? From them having to go to the probate court system to ask a probate court judge to give them legal authority to make decisions through the guardianship process or through the conservatorship process or both. When you create this durable power of attorney, you are giving up some or all of your decision-making power. That's a huge decision, right? We are all adults. We all have the right to make our own decisions and choose our own path in life until it gets to the point in our life where we're no longer capable of doing that on our own. And so by doing this pre-planning piece, you get to pick a person or people that you trust to make those decisions on your behalf when you're no longer able to do so yourself. But more importantly than that, you get to define the limit of the decision-making authority of that agent or those agents that you are choosing. And that's important as well. You're giving written instructions to that other adult human about how you want the decisions to be made, what the guidelines are, what the triggering event to give them the power to step in and start making your decisions for you looks like, and when there would be an end to their power, when they would stop exercising that power on your behalf. And what's most important is that these documents don't necessarily have to be frozen in time for all of perpetuity because life happens, right? And we need to acknowledge that. As long as you, as an adult human, have the legal capacity to make your own decisions and it's not been impaired by a physical or a mental health challenge, you can revoke a power of attorney. I suggest you do it in writing, but we'll learn a little bit later. Some powers of attorney you can revoke verbally, and that's still valid under Michigan law. Whenever you choose to revoke an existing power of attorney, though, make sure that you have already planned and put into place a new power of attorney or some new document or mechanism so that if in the future you can no longer make your decisions, you have that safeguard already in place. I want to focus on the word durable because it's important you understand that. The reason we want it to be a durable power of attorney is we want that contract to outlast your legal capacity to make decisions because we want the triggering event to be once you become no longer able to safely, freely, and voluntarily make your own decisions. So we want the contract to be durable. We want it to survive that point in time where you no longer have the ability to make your own decisions. And when we properly do this pre-planning piece, when we have these documents in place, properly executed, notarized, and properly witnessed, having this in place can help protect you from needing to have the court decide who your agent will be through a guardianship proceeding and or through a conservatorship proceeding. So I want to take a little bit of a deeper dive about that agency relationship. We spent some time talking about it last week as well, but for my folks who are new to this series or didn't weren't able to join last week, the agent is the person who's going to make your decisions on your behalf once the time comes. That agent, that third party, that other human being, they have what's called a fiduciary duty. They have a trust relationship with you, and they have the legal responsibility to follow the written instructions that you have put into the power of attorney document. The power of attorney is actually a contract. It's a contract between you as the principal, the person who is agreeing to give up some or all of your decision-making authority, and the person who will be your agent. They are accepting some or all of your decision-making powers from you, and not only that, they're agreeing to follow your written instructions and only act in your best interest when they're exercising authority under that power of attorney. So because it's a contract, all of the parties to the contract have to sign the paper document for it to be valid. Not only do you, as the principal giving up your power, have to sign that document, but your agent or agents who are accepting that responsibility from you also have to sign the document. The document needs to be properly executed. So what does that mean? So under Michigan law, it means different things for different types of powers of attorney. In general, the power of attorney has to be in writing. So nothing verbal that can be enforced. It has to be done in writing. Normally, depending on the type of power of attorney, we want to make sure that the principal, the person giving up the power, is in front of a notary public and is under oath, that everything in the document is true, that they read the document before signing it, that they understood the document before signing it, that they are of sound mind, and that they're freely and voluntarily signing the document. Nobody is coercing them into entering into this written contract. And so the notary watches, the notary has to examine a government issued photo identification of the principal that is going to be signing the document. And they have to put the individual under oath before letting them sign the document. And then the notary casts their magical notary spell over that contract by signing as the notary and sealing that document. But also, we need to have two independent witnesses that are going to watch the principal execute that document. And that's so important as well, because now you have at least two, if not three, because the notary can also be acting as an independent witness, right? You've created folks that if somebody kind of challenges the validity of this contract, you've created folks that can now be witnesses that can come to court and testify, oh no, I was there when Tracie signed this. I know that Tracie knew what she was doing. I knew that Tracie was of sound mind at that date and time. I watched Tracie sign it, so I know for a fact that this is not a forgery. And that is so important. That protects you as the principal, the person who's giving up some of your decision-making power. So the agent or the agents that you appoint through the power of attorney contract, they got to have their own copies. And Michigan law says that photocopies, as long as they're complete and contain all of the pages of the document, photocopies are just as valid and just as enforceable as the original wet signature version. That's so important because we want to make sure that you as a principal are giving copies of that completed contract to each of your agents so that they know where they are keeping their copy so they can grab it when they need to use it and show it to another agency or organization. We also want to make sure that the principal is giving copies of the power of attorney to the applicable service providers that might need to rely on it and might need to listen to or ask the agent in the future questions to make sure that everybody is doing things in your best interest for your care and for your well-being. And also remember, we talked about a little bit earlier that life happens. So make sure that you are doing yourself a favor and periodically look at those estate planning documents and those end of life documents that you may have executed in the past to make sure that they still say what you want them to say. People have falling outs. People die. What if you appointed an agent and you have a valid power of attorney, but the agent that you appointed dies before you do? You'll need to do a new power of attorney. You'll need to appoint a new agent or new agents because no, you don't have anybody in place anymore. You don't have that security through the power of attorney that you previously executed. And always keep in mind that the power of attorney dies when the principal dies. Because you, as the principal, as the person giving up some or all of your decision-making power, as soon as you make that life transition into the next, you no longer have any more decision-making power to give, right? So the natural termination of a power of attorney is when the principal dies. That doesn't mean that you can't put additional language into the document, further limitations on the duration of the agent's powers. And if you're doing the power of attorney for a limited purpose, that's important to clearly define when that transition of decision-making authority comes to an end. So consider that as well when you're in the drafting process. So before we start talking about specific types of powers of attorney, I'm going to take a pause because that was a huge information dump. Does anyone have any questions? Go ahead and take yourself off mute if you have any questions. And I'm also not able to see the chat while I'm sharing my screen. So Lisa's helping me out. So if there's any typed questions in the chat, Lisa can read those to me.
Hi, I have a question. Um, Hypothetically, if somebody, the individual with the power of attorney, does not specify the duration of the contract and they do pass, who then would be in charge of making further decisions for, say, assets or financials?
That's a great question. Thank you so much. So that's a great question because it identifies a specific problem with the power of attorney. The power of attorney dies when you do, when the principal dies. This is life planning that we're talking about today. We're talking about planning for taking care of yourself while you are alive. Once you die, there are different documents you need to have in place that'll take over at the moment of your death. None of your agents under a power of attorney can act on your behalf once you die using the power of attorney because that power dies with you. So in place, you have to also do end of life planning. You have to do planning and put documents in place while you're alive that will take over the second that you make that transition into the other world. And so when we talk about estate planning or end of life planning, that's when we need to make sure we're thinking about stuff like doing a will or creating a trust or doing a transfer upon death deed or ladybird deed for real estate. So those documents we're not focusing on today in today's session, but they're also very important documents to do while you're alive because we're all going to die someday, right? Might as well plan for it. Those are documents to do while you're alive, while you have the legal capacity to make your own decisions, because your agent isn't going to be able to do them on your behalf. And put those in place and properly execute them and keep them in a safe space so that your loved ones know how to find them and where to find them once you pass. Did that help or did that create more questions?
Thank you. That helped a lot. It sounds to me like the power of attorney isn't, kind of specified and focused on that aspect. So yeah, that really helps. Thank you.
Okay, great. No problem. All right. So let's talk about some specific types of powers of attorney. So we talked about the fact that it's a delegation of decision-making authority. We talked about the fact that it's a contract, but what we really haven't talked about is why you might want to do one. There's a bunch of reasons why people might want to do a power of attorney. And you have to be specific in the written language of the contract about what types of powers you're delegating to your agent. So, one example I like to give, because this might be a new concept to some or all of you, one good example of a type of power of attorney is a permission slip for a school field trip. So, if you've ever had the pleasure of helping raise a minor child that has gone on a school field trip and you had to sign one of those permission slips, technically that's a form of power of attorney. It's called a delegation of parental authority. Normal people don't call it that. That's what the law calls it. But you are delegating your right as a parent or a legal guardian of a minor child to the school and the chaperones or the agents of the school organization to act as if they are a parent for your child on that field trip because the child is going off of school grounds. So you're temporarily delegating your parental decision-making power to the school and the chaperones that are going on that field trip to parent your child while they are off school grounds on that field trip. So that's a form of power of attorney. Does it have a limited duration? Absolutely. Will it be on the face of the document? Absolutely, because the slip should state with specificity what you're giving permission for. You're giving permission for this minor child that goes to such and such school to go on a field trip to the Detroit Zoo on a certain date. And once that child returns to school grounds, that is the natural termination of that permission slip, of that parental delegation, of that type of power of attorney. So let's talk about a different type of power of attorney that adult individuals of any age might want to consider executing to prepare for end of life, to prepare for entering a phase of their life that where they no longer are able to make their financial decisions, where they're no longer capable of engaging knowingly and voluntarily in business transactions, and when an agent needs to have some kind of legal authority to step in and help the principal, help that person with financial and business transactions. And that's what we call a durable power of attorney for financial and or business transactions. So I'm going to walk you through what that looks like. So it's important to understand that this type of power of attorney is governed by that relatively new statutory scheme, that new Michigan law called the Uniform Power of Attorney Act. And when I say new, it went into effect July 1st of 2024. In the world of a lawyer, that is brand spanking new, but it is 2 years old at this point. So we've had some experience using it, and we've also had some experience litigating under it. So what that Uniform Power of Attorney Act says is that whenever you're doing a power of attorney, that gives up decision-making power over anything financial. That includes business transactions, that includes real estate transactions. You need to put very specific protection language in that contract to help protect you as the principal, the person that's giving up your decision-making authority. You have to put special magic words in the document to protect you from potential exploitation, neglect, or abuse by your agent or agents once they have the authority to start controlling your finances and your personal business and your real estate. That is so important. And it is so important that you include all of the special language that is now in Michigan law when you execute this type of power of attorney. What that in effect has done is it has made the contract that much stronger and it has enabled the language of the contract to track or to mirror the criminal law that's now in place to protect vulnerable adults. That's called the Financial Exploitation Prevention Act, or FEPA is the acronym. So those two sections of Michigan law work cooperatively to provide more legal protection for vulnerable adults from financial exploitation by their agents. And that's so important. So we're looking at the first page of a sample power of attorney for financial matters. And this is from my friend Kermit. Wanted to make sure that everybody knew this is not for a real client so that we can use it as an example freely today. And you can see in that first paragraph, we've got some very important magic words. We let everybody know that we're talking about the Kermit the Frog that lives in Macomb County, Michigan. We're not talking about any other Kermit the Frog. And Kermit is acknowledging in this first paragraph that they're voluntarily giving up some of their decision-making power that is subject to all of the written instructions in this document. This last part of the sentence is also really important. We are expressly revoking, we're calling take backsies on any prior power of attorneys that Kermit might have executed in the past that might appoint an agent that could make financial decisions for them or business decisions for them. So that's important. Even if Kermit, as my client, came to me and says, I've never had a financial power of attorney before, Tracie, I'm going to say that's okay. Don't care. You might have forgot, or someone might have forged one on your behalf and it might exist and you might not know about it. So we want to make sure it is very clear and in writing that anything that predates the document we're going to execute today is no longer valid. Now let's look at that second paragraph. That second paragraph has a specific reference to the Michigan law that controls the interpretation of this document. That is also important because this document, while executed in Michigan by a person who resides in Michigan, must be interpreted under Michigan law, even if it is being used in a different state or in a different country. Now, we can't control under United States law whether or not full faith and credit is given in a different country. And the reason that's important is we're right on the Canadian border, right? But we can control under the United States Constitution whether or not other states will give authority to a properly executed power of attorney under Michigan law. And the 11th Amendment to the United States Constitution says they have to. They have to give full faith and credit. But not only that, they have to enforce and interpret this contract under Michigan law, which very well could be different than the law in any state that is not Michigan. Because it's important to recognize that the laws are different in every single state, and the laws governing powers of attorney, estate planning, and end of life planning are different in every single state. Now, you'll notice at the very bottom in the third paragraph, it starts out by acknowledging that I might or Kermit might be appointing not only a first in charge, my initial agent, but may also be appointing a backup, a successor agent. And that's a best practice, right? Because that way you already have at least one backup appointed that you have also chosen. So if your first in charge is unable to act when it comes time for them to make those decisions on your behalf, and that could be because maybe they died before you did, or maybe they now live in Madagascar and it's inconvenient to rely upon them to control your finances. So if they're unable to act or if they're unwilling to act, you're first in charge. The person you pick first might be like, no, I don't have time for this. Or I can't. I'm too emotionally involved. These are decisions that I don't feel comfortable making for you. That's okay too. We have to respect that position. So that's why it's always a good idea to name at least one backup or one successor agent that can step in to the shoes of your first in charge if they're unable or unwilling. So let's go a little bit deeper in this document, in this sample document. It talks about when this power becomes effective. When can your agent step in and start actually exercising the decision-making power on your behalf? So we cite again to Michigan law because it's very specific, and we want to make sure that anyone relying on this document, whether or not they're an attorney, knows how to find the applicable law that applies to how to interpret or enforce this document. We also talk about who the agents are. And in this instance, my client Kermit has appointed Miss Piggy as first in charge. Now, we have to give enough identifying information for Miss Piggy so that it is very clear who this individual is so that they can provide adequate photo government issued identification to any banking establishment, credit card company, utility company when they are acting on my behalf to prove that they have my authority as the principal to be my agent. I also have to provide sufficient identification information in the written contract to identify any successor agents that I may appoint. I have also put the limitation in this document that this document does not become effective until I am determined by a treating medical professional that I am no longer capable of making my own decisions safely, freely, and voluntarily on my behalf. It's no longer safe for me to make my decisions. I no longer possess the legal capacity for decision making. And so there is another page further inside this contract where I can appoint a designated medical professional that can trigger the authority under this contract. Or I can just say any current treating medical professional and leave it vague like that because life happens, right? We don't know if my primary care physician may die. We don't know if I might change insurance companies and have to change my primary care physician. Or we don't know if I might be under the care of a certain specialist, a neurologist, or another type of medical professional that would be better suited to make that determination of the point in time when I can no longer make my own decisions and somebody else has to step in. Now we get into the meat of the document. We get into the specific language that defines what decision-making power my agent has or Kermit's agent has in this example. I urge all of you to be as specific as possible in this section. Now, you will see that what we have here looks to be boilerplate or form language. That's because it is. This is language that is now contained in Michigan law under that Uniform Power of Attorney Act so that we know what type of specificity Michigan law wants to protect the rights of the principal, of the person giving up their decision-making power. And we want that language in there. We want it to track Michigan law to prevent the potential and to protect against the potential exploitation that might come from the newfound power of your agent or agents. And then finally, we want to help define for everybody that might look at this contract what disability means. And so we cite to the Michigan law, and we also in plain language describe what that law says. So I want you to read paragraph 7 very carefully because we want to make sure that protection is in place whenever we're doing a power of attorney, but specifically it's required for financial powers of attorney and or for business transaction or real estate transaction powers of attorney under that Uniform Power of Attorney Act. And then we talked about proper execution. This is what the signature page looks like or will kind of look like, right? Not only will you have a signature line for the principal, for Mr. Kermit, but we've got that notary public block that the notarization is going to take place and be filled out. We're going to have the notary sign it. We are also going to have that acknowledgement of those two disinterested witnesses. One of those disinterested witnesses can be the notary. Sometimes your notary public will sign this document twice, once as the notary to cast the magical notary spell, and then again as one of your two disinterested witnesses. Remember, we talked about it being a contract. All powers of attorney are. This is the section of the contract where you have to, as the agent, acknowledge and accept all of the authority and all of the rules, guidelines, limitations of the contract document that the principal is putting in place. And so this section is that acknowledgement that the agent or the agents will sign to complete the contract. I'm going to pause again because that was a huge information dump. Does anyone have any questions?
Yes, I do.
Go ahead.
Oh, my name is Mimi, and my question is um, the new law that took effect in 7/1/24, does that apply to any POAs older, or do you have to redo or update to comply with the new law?
So that's a great question, and I'm going to lawyer up my answer. It depends.
Okay.
So Michigan law, the new Michigan law that has to do with these financial or these business transaction or these real estate powers of attorney, the new law says that if you executed properly under the old law a similar power of attorney and the date that you executed it was before the effective date of the new law, so you executed yours before July 1st of 2024, it is still valid and we still need to treat it as if it's valid. So you're not required to do a new one.
Okay.
But I have to say this because I got to lawyer up my answer.
Okay.
If you still have the legal capacity for decision making at this point in time, because now we are 2 years past that enactment date,
Mm-hmm.
I think you should do a new one if
Yeah.
you're able
Okay.
to, so that
Yeah.
we can put all of those protections in the language of
Okay.
it that the law has. Because
Okay.
if you did it under the old law, you might not have all that magic language. You might not have the magic words in that document. You
Mhm.
want to have that protection. You want that to be in place for you to help protect you against potential exploitation or fraud committed by your agents in the future. Because once your agents are able to make those decisions on your behalf, you're not going to have the legal capacity to change it. You're not going to have the legal capacity to call them out and say, hey, you shouldn't be using my checking account to pay your own mortgage payment. So that's where law enforcement steps in. And that's where you need those magic words so that law enforcement knows that they can step in. Does that help?
Yes.
Okay. All right. What else?
All right, so we have another question. It's in the chat, but Vanessa, I see you have your hand raised, so would you prefer to verbalize it or I can go ahead and read it. So our question is, would it be common for an individual to not know that they are serving as an agent for someone?
Would it be common? Unfortunately, yes.
Mhm.
But you can't act as an agent for someone until you have countersigned the contract, the power of attorney contract, right? So you necessarily, before you can exercise any decision-making power on behalf of that person, you necessarily have to know because you got to countersign the contract to make it a complete and enforceable contract. So, is it very possible that someone has executed properly a power of attorney form yesterday, 2 years ago, 5 years ago, that appoints you as their agent and you don't know about it? Yeah, that's very possible. It happens all the time. But before you can act on that person's behalf, you have to sign that acknowledgement portion and complete that contract. So I'm glad you asked that question because that brings up an important part. Usually when you think of a contract, everybody signs it on the same day, right? This type of contract, you don't gotta. Michigan law is very specific. As long as everyone has signed it, it doesn't matter if it happened on different days. The contract can still be relied upon and can still be enforced. Now, what does have to happen on the same day is the principal or the person that's giving up the power, that's executing the power of attorney document, no matter what type of power of attorney document, that person has to sign it in front of the notary and in front of the two disinterested witnesses. And those parties have to countersign at the same date because they necessarily have to be physically present before the principal can validly sign or execute the power of attorney document. So that first signature page that I showed you that has the signature of the person executing or giving up some of their power with the notary block and with the signature lines for those two disinterested witnesses, all of those dates have to match. But the agent signatures, those dates can be at some point in the future and it's still treated as a valid contract. Did that help or did that cause more questions?
That was good. I understand it. Thanks.
Okay, awesome. All right. Any other questions before we talk about healthcare power of attorneys? All right, let's press on. We're going to keep going. If you think of another question, we can always go back in time. Not a big deal. Let's talk about a healthcare power of attorney. So some people call them durable powers of attorney for healthcare. Some people call them durable powers of attorney for medical care. Same. Doesn't matter what you call them. But we know that this type of contract, this type of power of attorney, the intent is to give your agent or agents authority to make medical decisions on your behalf and to make decisions involving the care and custody of your body and soul, right? So if you have a valid financial power of attorney in place, that protects you from somebody down the line needing to go to probate court and file for conservatorship over you. Because if you remember from last week, conservatorship is asking the probate court judge for legal permission and legal authority through a court order to make financial decisions and business transactions on behalf of a protected individual who no longer has legal capacity to do it on their own. If you have that financial power of attorney in place and it's still valid, nobody needs to also go and get a conservatorship over you. So the healthcare power of attorney is about care and control of the person's body and well-being. So if you have a valid power of attorney for healthcare or medical care in place, that protects you from one of your loved ones having to go to the probate court in the future to get guardianship over you, because this power of attorney stands in the place of the probate court guardianship order. Now, if under any type of power of attorney, the agent is misbehaving, any other adult individual, including the principal, can file with the probate court a guardianship or a conservatorship petition saying, I want to get rid of this power of attorney because my agent is misbehaving. I want the court to help. And I want the court to figure out who would better be acting in my best interest on my behalf. So you can always go to the probate court. That is your safety valve if the agent or the agents are misbehaving or breaching that fiduciary duty or that trust that we talked about. All right, so let's look at a sample power of attorney for healthcare. So I don't know how many of you are locked into the Marvel Cinematic Universe, but I'm kind of a nerd, so I'm letting my true colors fly here. So this is a fake power of attorney for healthcare for Captain Marvel. Carol Susan Jane Danvers is her legal name. That's her government name, but we all know her as Captain Marvel. And so you'll see in this first paragraph of this fake power of attorney for healthcare, I am addressing everybody who might be involved in the care and custody of my body, my well-being. I'm letting them know this document talks about how I want my medical and health care to go, and I want you to follow my instructions. And similar to the one we just looked at for finances, I also have language in here that says, me as the principal, I am expressly revoking or calling take backsies on any power of attorney for healthcare or any advanced directives I may have executed or signed on any date before today's date. All right. And we talked about how that protects you, because even if you didn't do a previous one, it protects you if somebody may have created a forgery or created a fake one on your behalf, right? That predates the new one that you're doing. But maybe you did one and you forgot about it, or maybe you did one and you didn't realize it, because that happens all the time too. Your probate attorney or your estate planning attorney gave you a huge stack of documents. You just signed them all. You didn't understand them. Happens all the time. Doesn't happen to my clients because I am painfully obvious. I want to make sure you know what you're signing. But it does happen all the time. And so we want to make sure that we are expressly getting rid of or invalidating anything that predates this new one that we're doing. And then you'll see at the bottom of the page, we are appointing and we are naming and we're giving enough identification information about who we want to be my agent, my first in charge, to make my healthcare decisions when I'm no longer able to communicate them myself. So I have appointed my friend Maria to do that. And I have given enough identification information about Maria so everybody knows that they are talking to the correct Maria as my agent. So under Michigan law, we use some different terminology for the healthcare power of attorney. The agent is now called the patient advocate. It means the same thing. If you do a power of attorney for healthcare and you call it an agent, nobody's going to care. It doesn't make a difference. They're interchangeable terms of art. Take a deeper dive. Let's go a little further into the document. In this document, I'm going to set forth some very specific instructions for my health care. Now, you can use a power of attorney for health care to govern both your physical health care decisions, and you can also have it include your mental health care decisions. But because that triggers two very different areas of Michigan law, we have different sections in a healthcare power of attorney that talk about physical health versus the section that talks about mental health. And that's for very good reason, because if you are having an agent make your decision for physical health because you're not capable of doing it on your own, you still have the absolute right to revoke this power of attorney, even verbally, at a moment's notice. You can tell your doctor, hey, I don't want Tracie making my healthcare decisions. She's not doing what I want her to do. And they have to respect that choice. You don't have to do it in writing. But for mental health care decisions, the law puts additional protections in place for the principal, for the person giving up part or all of their decision-making power through this power of attorney. Because if you are in mental health crisis, it may not be safe for you to call take backsies at that point in your life. You may not fully understand the ramifications of a revocation if you are experiencing a mental health crisis. And so Michigan law puts additional safeguards in place, and you'll see that language later on in the sample power of attorney, that if this is triggered for lack of capacity because you are facing a mental health crisis, or you have a degenerative physical disease that is affecting your capacity for decision making, such as dementia, then you have already given up your right and ability to revoke this for a certain period of time. And that's for your protection so that you're not engaging in self-harm or self-neglect as a result or as a symptom of that mental health crisis. So let's stick with physical health for right now, because that's what we're looking at. So, what's the first question that your healthcare treaters always ask you when you show up at urgent care or show up at your doctor's office or show up at the emergency room? What are you allergic to? Your agent might not know the answers to that question on your behalf. That's why it's important to put it in writing, because you should know the answers to those questions. So you'll see in bold, I am allergic to the following medications or drugs. If you have any food allergies, I think it is a best practice to also include that in your healthcare power of attorney. Because again, your agent may not know, and it's very important for everybody to understand that a lot of medications have food products in them. And I'm going to give you a real life example. My mom is allergic to raspberries and blackberries and boysenberries and everything in that family of berries. Do her doctors need to know that? Well, they're not going to be feeding her raspberries while she's on the operation table, are they? But they need to know it. Why? Because raspberry is a very common additive that is used to color pills. And so if my mom gets a pink pill like lisinopril, she probably is going to have an allergic reaction to it because raspberry was used to color that pill when it was made. Normal people don't know that. So that's why it's important that your agent knows what your food allergies are as well, so that the doctor who will know that knows to prescribe a different form of medication to control whatever physical challenge that you're facing. Another common food product that shows up in a lot of different medications is egg. So if you are allergic to egg or egg products, you must, well, you're not required under the law to list it, but I certainly recommend that you list those food allergies in your healthcare power of attorney as well. Now, people have strong feelings about a lot of different types of medical procedures. And over the years, we've kind of at Lakeshore Legal Aid collected a laundry list of the types of medical procedures that people have expressed strong feelings about. And we want to make sure that not only your healthcare professionals know what you have strong feelings about, but that your agents know that as well. So that's what section B and C talk about in this document. And so these are some things to think about when you're putting together your medical or your healthcare power of attorney. Do you want CPR if your heart stops? If you don't, please put it in this document. If you are no longer able to swallow because you have gastroparesis or you have muscle atrophy, or if you have other things affecting your ability to eat and to swallow, such that you would need forced nutrition through a feeding tube to continue to survive, if you don't want a feeding tube, put that in this document. Put those written instructions in place while you can, while you have the capacity to do that. Because once folks actually look at this document to follow it and rely upon it, it's going to be too late for you to talk about stuff like that. So it's very important that you include a limited waiver of your privacy rights under federal law in any healthcare power of attorney, because you definitely want your agent to make educated decisions in your best interest. And to do that, they got to be able to have your permission to talk to your doctors and to look at your medical records so they can make educated choices on your behalf. But even if you lack the capacity for decision making or communication, you still have privacy rights under HIPAA. You still have those privacy rights under federal law. And so it's important while you have the capacity for decision making that you voluntarily do a limited waiver of those rights to your agent or your patient advocate. so that when it comes time for them to exercise their authority, they can make educated and safe decisions for your medical care and treatment. And then finally, you're going to properly execute the document. And so we've got some magic language in here, including what I have in bold. Photocopies of this document may be relied upon as though they are originals. And we talked about that a little bit ago. That's important. I think that's so important to communicate not only to your agent, but also to anybody who might rely on this document, any doctor, any psychiatrist, psychologist, EMT, anybody that might be providing any form of care or custody over your body or well-being. They need to know they can rely on that photocopy as if it was the wet signature original that you executed. We have a signature line for the principal. We have that notarization block that we talked about in the other power of attorney. We're going to make sure, oh, and I didn't give you a screenshot, but we also are going to make sure we have those 2 disinterested witnesses. All of those folks need to watch you sign as the principal. The notary has to look at a government issued photo identification to prove that you're not trying to forge someone else's name on this document. It's that important. So now, remember, we saw this as we looked at the financial power of attorney. We also have to have a complete contract. We have the acceptance portion of this power of attorney. This is the portion where your patient advocate, where your agent is going to countersign to complete the contract and to acknowledge that they have a duty to follow your written instructions and they have a duty to follow Michigan law. I'm going to pause again and open the floor for questions.
Nothing in the chat.
Okay, thanks, Lisa.
Mhm.
I'm going to keep going. If people think of questions, feel free to interrupt me so that I can answer your question before we get too far afield and forget. I don't want anybody to leave here with questions that we haven't talked through for you. So next I'm going to talk about the advance directive, or what normal people call a living will. So let's talk about that living will. So with an advance directive, you are choosing your end of life treatment plan. You get to put into writing your important medical care decisions while you have the ability, while you have the legal capacity to make those decisions on your own. You are providing very specific written instructions for your medical treating professionals, as well as any agents or loved ones in your village, about how you want your end of life medical care treatment to go, because you may not be able to communicate that when the time comes. You might be unconscious. You might be under the influence of heavy pain medication. You might be mentally impaired. You might not be able to speak. There are so many variables that can affect your ability to communicate safely and in your own best interest. And so the advance directive, I look at that as a gift that you're giving to the people that love you, and you're letting them know the specific instructions when it's okay for them to let you go. Some people call a living will or an advance directive a do not resuscitate, but it doesn't have to be that. You can be creative as you want to be. It's your energy, it's your life. You decide how you want it to look when you are reaching the end, when you're getting close to making that transition. And I'm not trying to make light of death. I talk about death and dying all the time. It is quite literally my job. So I've kind of taken the emotion out of this discussion. It's okay to be emotional, and it's very human to be emotional about the end of life planning process. So please give yourself grace. And when you are going through this process, even when just now, when we're having this conversation and you're considering what types of decisions you may want to make and put into writing, that's hard. That's heavy. That's okay. Acknowledge those emotions. That's important as a human. So when you are doing an advance directive, it's only good if someone can find it. So I would recommend that if you execute an advance directive or a living will, that you give copies to all of your current healthcare providers and ask them to make it part of your medical records file. That's so important. Also, no one can predict the future. I think you should keep a copy in any vehicle that you might be traveling in. If you go on vacation, take a copy of all your documents with you. If you carry a handbag, stick a copy in that. Make sure all your loved ones have a copy or at least know how to find a copy when the time comes to rely upon it and follow those instructions. Make sure that if you're doing this living will, that you have the important health information that we just talked about in the power of attorney for healthcare. These are two separate documents. You can combine them into one. I often do, but you don't have to. They can be kept separately. So if they are going to live as separate entities, as separate documents, you also got to talk about your medical history, your medication allergies, your food allergies, all of those things that the person that is giving you medical care needs to know so they don't make your condition worse inadvertently. We want to make sure that you explain in your words with specificity why you want things done a certain way, why you're making these decisions, and why you want people to follow them. And also, this is one type of form that the hospital social worker is going to have a stack of. They might call it a do not resuscitate as well. But like I said, and we're going to talk about on the next couple of slides, you can make it say whatever your personal wishes and desires are. The hospital forms are more often than not check the box forms. Check the box, sign it in front of a witness, and it's good to go. I like to have a little more detail than checking boxes, right? I am a unique individual. I want my end of life planning to be unique as well, and I want to have control over the language that it contains. So while you have time and capacity right now, get it done. Make sure you have it say what you want it to say, and you're not forced to do that square peg round hole of a checkbox form. So here's one example of a type of advance directive or a type of living will. You can do a do not resuscitate. A lot of people do. That is a valid choice. Some people call it a DNR. Here's some sample language that I've used over the years for different clients. So consider all of these options. You don't have to use any of these options. You can say something different, but this is one example of what an advance directive might include. Let's look at example 2. Here's some different type of language. So this is the other end of the spectrum, right? This is the other end of the rainbow. I want my life prolonged as long as medically possible. I want heroic measures. I want CPR. I want to be on a ventilator because humans should not decide when I go out of this world. That is also a valid choice. And here's a couple of example paragraphs on how you may choose to express that intent in your advance directive or in your living will. But most people are somewhere in the middle, right? And so that's why I have example 3 here. Most people fall somewhere in the middle of that continuum that we've looked at both extremes. And so here's some examples of language that I have used over the years to help people bridge that gap and fall in the middle. Some folks like to put time limitations. Yeah, if I can't breathe on my own, go ahead, intubate me, put me on a ventilator. But if I have to be on a ventilator for more than 30 days, then pull the plug. If I'm on a ventilator for more than 30 days and I have an irreversible medical condition that ultimately is going to result in my death, pull the plug. Those are all valid choices. So make sure that you are putting a lot of thought into what you want, not what somebody else may want, not what other people have chosen, but what you want, how you want to describe your end of life choices to your medical care professionals and to your loved ones. I think it's a gift, right? Because when the time comes for your loved ones to have to talk to your doctors and make these decisions at the end of your life, emotions will be high. I guarantee it. And I'm going to give you a real life example, and I'm going to try and do it without crying. My dad passed in 2014, and I still have strong emotions about this. But I knew for a pretty close to a decade before the end of his life, I knew that he wanted to be a do not resuscitate. He was very clear always. He would bring it up in conversation with me and my mom. He had it on his driver's license. He had an advance directive that was properly executed in place because his daughter's a lawyer. But he was always very clear. But when he had his heart attack, and I had to make the decision, I would have made a different decision, right? I didn't want my dad to go. So it was a gift that he gave me to be able to make the decision he wanted. Sorry, lawyers are humans too. So I like to give that example though, because I think that gives you some context to kind of help you frame how you may want to make that type of decision, and how important it is to do that while you can. All right, let's do a comparison contrast because the advance directive is very different from that contract, that durable power of attorney for healthcare, even though you can combine them in the same document. So the advance directive, not a contract, it's a directive. It's your orders to your medical care professionals and your loved ones. This is how I want to go out. The power of attorney is a contract. This is how I want my medical treatment decisions to go. And you, as my agent, are agreeing to follow my instructions and communicate thusly to my medical care professionals. In the advance directive, you made all your own decisions. This is how I want to go out. In the durable power of attorney, you've given written instruction, but ultimately, you're no longer capable of communicating. Your agent or your patient advocate is the one making the decisions at that point in time. The advance directive, like I said, you can do that while you're in the hospital or in the doctor's office. People do it all the time. Usually the durable power of attorney has a lot more preparation and a lot more forethought and pre-planning in place. You usually do that in the lawyer's office or at your home or at a location of your choosing. With the advance directive, doesn't need to be notarized to be valid. With the power of attorney, because you're giving decision-making power to another person, you want it to be notarized. That protects you from forgery. That authenticates the document, and it gives you a person who has been insured and bonded by the state of Michigan as a notary who can say, yep, she was of sound mind. She voluntarily executed this document. No one forced her to do it. And it was actually Tracie that signed the document. I know I saw her government ID. With the advance directive, you also don't have that requirement of having those two independent witnesses like you do with the power of attorney, and you're not waiving your HIPAA protections. You're not waiving those federal privacy protections with the advance directive because you're just telling, this is how I want to go out. And nobody has to make any of those decisions on your behalf. I'm going to leave this slide up for a minute and see if there's any questions.
There is one question in the chat. How do people say they want to be comfortable and preferably free from or minimal pain to transition out with non-severe treatment?
I think that's a beautiful way to say that. But you can add words. You can be as creative as you want and need to be when you're talking about your end of life medical treatment. So that's why I gave you a whole laundry list of different examples of language that other people have used. That doesn't mean that you need to use that language. I always like to talk with specificity about the use of pain medication because some folks don't want pain medication, and that is their choice. And so I always like to talk about specificity about how that should look. Certain types of medical treatment. I don't know if you remember that section of the power of attorney where we listed specific medical treatment like feeding tube, cardiac resuscitation, antibiotics, blood transfusion. So those are all types of medical treatment that over the years people have expressed to me and to others within Lakeshore Legal Aid. These are things people have strong feelings about. I'll give you another real life example. My husband was raised Jehovah's Witness. Part of his belief system is that he shall not receive the blood of another human being, no blood transfusions. And so that's in his power of attorney because he needs to make sure that not only I know that as his patient advocate, but that all of his treating medical professionals understand and respect that choice. That is a personal choice. And so, to the extent you have strong feelings about anything, medical treatment, pain medication, pain management, um, being in a persistent vegetative state, and whether or not you want to be kept alive if you're never going to recover consciousness, all of these are things that you should put in writing because when the time comes to make the decision, either through a patient advocate or because of the advanced directive being in place, you won't be able to communicate that stuff. So that's why it's important to put it in writing now. Did that answer your question or did that cause more questions? All right, I'm going to move on because I talked too long and I'm getting a little short on time. Um, I will stay as long as I need to. So if folks need to peel off, I respect your time and I'll try and get finished up right quick. So we talked about already, I like to combine these two documents. You don't have to. They can be separate documents, but you also can combine them as well. Come on back. This is my advertisement. Come on back next week, August 13th. We're going to talk about what to do with my stuff. So that was a question that I believe it was Vanessa had asked early on in the session. What happens when I die? Who's going to know what to do with my house, what to do with my car, what to do with my pets? Let's talk about that next time. So that's where we talk about all of the planning you need to do for what happens after you die. So that's the will, that's the trust, that's the transfer upon death deed for your real estate or the ladybird deed. That's putting beneficiaries on stock or other negotiable instruments. That is putting a transfer upon death or a beneficiary on your bank account. Not necessarily a joint account holder because there's a lot of legal baggage that comes with that. We'll talk about that a little bit more next week, but I want to make sure that that's on everybody's radar. So come on back next week. We're going to talk some more. And I have a pop-up. I apologize. So I want to tell you how to get to us. We do our intakes for potential clients in a myriad of different ways. The first way is over the phone. We have a centralized call-in intake system through our counsel and advocacy law line. The information is on this slide. I'm going to go too fast. You're not going to be able to write it down, but Lisa has my slides. She can send those out to you. Just let her know you want a copy. I have to tell you that we have the privilege of doing community education sessions just like this free of charge. And all of our services are free. All of our legal services are free. I'm a free lawyer. How often do you hear that? We have the privilege of being able to do everything for free because of all of these wonderful grant funders and so many more. We have 29 different grants that give Lakeshore Legal Aid the privilege to provide free services to the community. And these are just some of them. And I want to thank you for your time and attention today. There is a QR code on your screen right now. Our grant funders want to know how we're doing. This is a brief anonymous survey. So if you're willing, use your mobile device just to scan this QR code, fill out a couple of quick questions. If you have any thoughts about presentations you might want us to do for the community at future times, let us know. And with that, I am going to turn the floor over to Lisa and to all of you. Were there any questions or points of discussion that you want to pursue in our last 8 minutes?
Oh, thank you, Tracy. That was absolutely wonderful. So much information, a lot to digest. So the great thing is, as I stated at the beginning of the presentation, this presentation has been recorded. I do see a question in the chat about the missing that first session to the series. That was recorded as well. And those recordings will be posted to our YouTube channel. You just need to subscribe to our YouTube channel to gain access. So before we go, I do not want to inundate you all with, oh, evaluations. But the evaluations help us, improve upon the work that we're doing here, and just make sure that we are meeting your needs. So I just dropped the link to the SRC evaluation in the chat, as well as you can scan the QR code here. I will also send out a follow-up email reminding you to please complete the evaluation. And then we also just want to remind you all to please stay connected with the SRC. Again, scanning this QR code will take you to all of our socials for you to sign up for our newsletter and hop on our Instagram and Facebook page and LinkedIn pages. So again, we appreciate you all joining us today, and we hope that you found value in this workshop today. And we look forward to seeing you all again next time. Thank you.
Thank you very much. It was very informational. Thank you. Bye.
Awesome. Thank you.